be turned off and put away, please.
Please rise. Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division draw near to the attendance and you shall be heard. Please be seated.
Welcome to the Appellate Division First Department. We have over 6 hours of argument time requested, so please ask only for the time that you need, not the time that you wish. We are familiar with the briefs and the records, and if we have further questions, we keep asking them. People versus Phillips, appellant.
Good afternoon, appellant request 3 and 1, Your Honor.
Respondent. 3, 1, and 3. Brown versus Z Live Inc., appellant.
Good afternoon, Your Honor. 5 and 2.
Is respondent here? I'll give you 3 minutes, just. Dexter versus Mercedes is submitted. Volquez versus Bronx 2120 Catona, appellant.
Good afternoon, yes, requesting 5 and 2.
Respondent?
Respondent requesting 5.
5, 1, and 5. GSC Second Avenue versus Cohen. We are going to have both of those cases argued together. Respondent? No, we're doing them together. 6, 1, and 5. People versus McLaughlin, appellant. Respondent? 6, 1, and 5. Rodriguez versus Santos is submitted. Mo versus Zhu, appellant. Respondent? 6 and 2.
I'll ask for 5 plus 2.
Well, you don't have an appeal, so you don't get rebuttal time. 6, 1, and 5. Mariah versus Genting, appellant.
Mariah versus Genting.
How do you pronounce it?
Mariah.
I wasn't even close. Wow, Mariah. Okay.
It's less complicated.
Less complicated than it looks.
Your Honor, 6 and 3.
Respondent? 6, 1, and 5. Fortress Credit versus Cohen, appellant.
Appellant, Judge, 5 and 3, please.
Respondent? 5, 2, and 5. CR versus Episcopal Diocese. Appellant? First appellant?
First appellant 7 and 3.
Second appellant?
3 and 1. Respondent 5.
6, 1, 3, 1, and 5. Triad Capital versus Patino, appellant.
Good afternoon, 8 and 2 for the appellant.
Respondent?
Request 6 for respondent.
6. 6, 1, and 6. Alicia versus Windstar Service, appellant. That is submitted. I'm sorry, I didn't see you.
That's okay, I'm here for the,
Not because you were wearing a mask, I just didn't see you.
it's okay, I was sitting very quietly. I'm for the respondent, I don't know if you need or want to hear me. If
No, we're fine with submitting it. Everybody's okay with submitting it? Okay, it's submitted. People versus Valera, appellant? Respondent? 5, 1, and 5. And Scott versus Kosova is submitted. So our first case is People versus Phillips.
Good afternoon. I'm Danielle Bernstein from the Legal Aid Society on behalf of Ms. Shaniqua Phillips. Your Honors, when a person admits guilt during a plea proceeding, that is the moment that that person becomes convicted under New York law. That is why it is essential that the plea court ensure her understanding of the constitutional rights she is forfeiting before she admits her guilt.
Can you first address the issue of preservation and how this claim is preserved in this case?
Sure, Your Honor. Lopez doesn't require preservation here because this is a situation that calls into question the validity of the plea, so it fits squarely in that category. And even if it didn't, this court may reach it in the interest of justice. So if I may return to the order of events here, in this case, the Boykin colloquy happens after Ms. Phillips goes through her legal and factual allocutions. Now,
How does it go to the validity of the plea?
because, Your Honor, the plea happened already before the court went through those constitutional rights, and the order does matter. If I can make an analogy, in other departments, in the second and fourth departments, they have held that if a court conducts its appeal waiver colloquy, something that does not have a constitutional dimension, after a person has admitted their guilt, that vitiates the appeal waiver altogether. And again, that's something of far less significance than the constitutional right that someone forfeits by entering their guilty plea. And the reason that those courts have offered for why they've had those holdings is because everything that's on the table that can be waived or forfeited by a guilty plea has to be done before making that final commitment, before saying those magic words that make someone, in this case, a convicted felon. I mean, the consequences of that are really extreme. And so it's not really about a belief in formalism. It's about the actual consequences that attach by having that person enter that plea before the record reveals that they actually have affirmatively given up those constitutional rights and that they actually understand those rights. And I would also add that this court has actually already indicated a preference for courts to conduct those Boykin colloquies in dicta before soliciting that admission of guilt. In Williams, which two members of this panel were on, which was only about appeal waivers, this court—
On the merits, why wasn't this sufficient, the plea?
because
Why
of the
wasn't
order of— sorry.
Well, the main issue is the timing of, so why was that by itself insufficient based on all the other factors, which would argue that the plea was sufficient?
Sure. Well, again, the timing, I think the way to think about it, Your Honor, is that because she's admitted guilt and the consequences attach at that time, we almost have to operate as though that colloquy that happens after didn't happen at all, because the consequences attached as soon as she admitted guilt. But even—
So if this matters, why wasn't there a motion to vacate the plea before sentence?
because, Your Honor, that would rely on an understanding by a defendant who was here for her first and only arrest, her first ever conviction, and very little formal education to understand that the
It was
court needed—
represented by counsel.
Sorry, say that again, Your Honor.
Defendant was represented by counsel. I mean, why didn't, if there was a decision that this mattered, why wasn't there a motion to vacate the plea? I mean, doesn't—
Your Honor, it's certainly not a knock on counsel on our part that we're saying that this is an issue that calls into question the validity of the plea. If I may finish, Your Honor. There are many situations where the Lopez exception is applied, where we've said that the validity of the plea is called into question, where counsel didn't make that motion. You know, we can't rely on counsel's evaluation of whether this was valid when we're talking right now about whether these constitutional rights were accurately forfeited in the lower court. Thank you.
Thank you, and sorry for your injury.
So, Your Honors, I think in evaluating the totality of the circumstances, it's not that the court has to make a blanket ruling right now to say that Boykin rights must always happen before the admission of guilt. It's that in this circumstance where we have a defendant who once again was facing her first ever arrest and conviction, that weighs very heavily in favor of this order being problematic, because the Court of Appeals has already said that defendants in those circumstances require a higher level of care than defendants who are not in those circumstances. And in Castillo, we were talking about an experienced defendant, and that is a very big distinction here. I just would...
Why did the defendant not ever move to withdraw the plea between the time of the plea and the sentencing if she was concerned about this?
Well, I think, again, that goes to the issue of what her level of experience was, Your Honor, because...
That was a month she didn't have a chance to speak to her attorney?
Your Honor, discussion with counsel is obviously relevant and an important thing, and again, we're not knocking the lower counsel here. The issue is that that's not a substitute for a record from the trial judge that demonstrates that affirmative forfeiture of these constitutional rights. And so that's what we're talking about here. Yes, the totality of circumstances also incorporates the fact that she has experienced counsel, absolutely. But the record that we're looking at here still reveals, if I may just finish, Your Honor, that she did not come to that demonstration of understanding until after she had already under oath admitted guilt to this offense.
Thank you.
Thank you.
Brown versus Z Live.
May it please the court, Payne Tadich for the defendant's appellants, Z-Live defendant's appellants. The Supreme Court should have granted Z-Live summary judgment because it demonstrated that plaintiff's assault was not reasonably connected to any sale to a visibly intoxicated person.
Let me ask you, how did you make a prima facie case here?
Yeah, so the elements, obviously, there has to be a visibly intoxicated person, they're in a bar, they're served a commercial sale of alcohol to that person, and then there's some reasonable connection between that sale and the accident.
You don't have a bartender from that night saying, we didn't serve this person, or someone from that evening saying that person wasn't in the premises, who was there and present. So what is it that's sufficient in this case to establish that
Well, we know
these
what
two people weren't served excessive amounts of
we know what the cause of the accident was, or at least one of the causes, is racial animus. This was charged as a hate crime. They were using the N-word racial slurs both before and during the assault.
Really, the relevant issue is whether or not you were serving too much alcohol to these two people. And how
Well,
did you prove that you were not serving excessive amounts?
Well, it's also that they had to be visibly intoxicated because that's what the law requires, right?
So how do you prove?
Plaintiff, nowhere in this record, anywhere, were these people slurring. They weren't stumbling. They didn't have glassy or bloodshot eyes. And the testimony actually is very affirmative on that they walked up to the site, they engaged these people, they engaged in racial slurs.
Isn't what you're talking about now speak as to the gaps in the potential gaps in the plaintiff's proof as opposed to you sustaining your burden?
Well, I would say that proves they weren't visibly intoxicated at the time of the assault. And with regards to in Z-Live's establishment, we had Toledo, who is the general manager. He was there that night. He said, I was there that night. I'm in charge of the cameras. There were no visibly intoxicated people, and we have very strict
Those cameras, it was unclear to me. The surveillance footage that was reviewed by Toledo, was that footage of inside the establishment in all three parts of the establishment, or was that outside in the street?
So my understanding is he's in charge of all of the cameras, but that
What he's in charge
review,
of. I want to know what he reviewed.
yes, the review the day after he had with the police, that was the footage outside of the facility.
Right. So there's nothing in this record to say he reviewed the surveillance cameras inside and these two defendants were not in. There's nothing capturing them drinking or intoxicated. They just were absent. There's none of that in this record, correct?
With regard to the video, that's correct. But Toledo himself was there. He said, I didn't see them. He spoke to other individuals, including the doorman. They said there was no incident.
Is there any evidence that they were drinking alcohol in defendant's establishment?
Not one bit, no. There's no receipt, there's no testimony. In fact, all the plaintiff has said is that 30 minutes after the bar was closed, he saw them walk out the front door.
And what's the evidence that your bartenders didn't serve alcohol to these two individuals?
Because if they had done that according to the protocols, these people would have been thrown out and a report would have been generated. And we also know at the time of the entire encounter, they weren't visibly intoxicated. They didn't have any of those hallmarks of the dram shop cases.
So what does Toledo testify as to what went on inside the bar?
He says there was a special ticketed only event from 11 p.m. to 3 a.m., at which time they close, and that based on his observations while he was working there were no visibly intoxicated people, that everyone was certified, there's the TIPS training.
So he testifies that as to that night, he
was there that night.
He's saying that there was no one visibly intoxicated.
Yeah, he says, I believe it's 405, 406, he says, I was there that night and there was no incident, and before that he describes these incidents as, we have very strict protocols. If someone's
There are
visibly
three establishments in that building that's owned by defendant, correct?
I'm sorry,
There are three establishments or spaces in that building that are owned by defendant, correct?
that's correct.
And am I correct in saying that two of them were in use that night?
No, one of them was in
Only
use.
one of them was in use?
Yeah, so there's the Cantina rooftop that night. It
So they do
closed at
serve-
10
They
p.m.
do serve liquor there, correct?
They closed at 10 p.m.
Do they serve liquor?
Yes, they do.
And he's saying, so his specific recollection is there was no one intoxicated there that night.
That's correct. And we're specifically talking about at 3 a.m. when these individuals had this encounter. So the rooftop bar closed at 10 p.m. The next level down was actually not in operation in February of 2019. So then all that was left is what's called stage 48. They have the second and first floor, but there's only bars on the first floor. So that's one establishment with 2 floors, 1 bar. There's no evidence that these
That's what
individuals...
Toledo managed?
I'm sorry?
That's what Toledo managed?
Yes, that's correct. Yeah, he was the manager of the entire facility. I know I'm over
Thank you.
time. Do you have any?
Any
Thank you.
further questions?
Thank you.
Okay, thank you very much. Vasquez versus Bronx 2120.
Good afternoon, Your Honors. May it please the court, James Drexler for the defendant appellant. In 2021, this court held that relevant considerations as to whether a sidewalk defect is substantial includes the defect's width, depth, elevation, irregularity, appearance, along with the time, place, and circumstances of the incident. That was in the Trinidad case. And liability, of course.
There are pictures in the record which show a not insignificant sidewalk defect, aren't there?
The photographs in the record that the plaintiff relied upon are inconclusive. First, because...
How about the picture at 174?
At 174, does that one have the ruler in it?
Yes.
So the ruler, first of all, is not flush against the bottom of the sidewalk flag. And the height differential is only really shown on one portion of the sidewalk flag, which leads into the next crucial point, that plaintiff testified the defect was on the northwestmost edge when he stepped on it with his right foot. That's a problem for plaintiff, because if that's true, then his left foot would have been poised to collide with the tree that was situated in the tree well directly adjacent to the northwestmost edge of the flag.
Isn't there evidence in this record that the defendant knew of the height differential for at least 2 years and in fact had called 311 over 50 times about this?
Your Honor, that there is evidence in the record to that. However, the defendant here never admitted to liability. If anything, he was being a conscientious building owner, which New York should applaud and be happy with. His attention to what might have become an issue is not conclusive as a matter of law with respect to the defendant's liability here. And that finds authority in the Agard v. Greentree case, this court, 2020.
How about the picture at page 170 of the record?
I don't have that right in front of me, Your Honor.
I don't know if you can see it from here.
It shows the sidewalk flag.
Yeah.
Well, again, the issue there, well, there's a few issues with that. First, the height differential. Plaintiff first said it was about 2 inches. The court below disregarded that. They rejected that contention.
The differential in 170 doesn't look insignificant.
Doesn't look insignificant?
Doesn't look insignificant.
Well, the court below held that it's not only is it not 2 inches, it's much closer to 1 inch, which would be, there's plenty of myriad of cases in the second department and first department that would say anything in that 1 inch range or lower is trivial and non-actionable.
But didn't the court, in granting plaintiff's motion, found that the investigator's affidavit established that the defect was elevated at least 1 inch above the adjacent sidewalk flag, thereby comprising a trip hazard within the meaning of the statute? And then she found for the plaintiff.
Well, she did find for the plaintiff, but again, that goes to where exactly the plaintiff stepped on this flag.
Yeah, but he circled the area where he fell.
Which is where the highest height differential would have been, which the court concluded was much closer to 1 inch. But we see it's impossible that he stepped where the height differential is the highest, because if he did so and he testified that he was walking straight and looking forward, then his very next step would have gone into a tree. And that's just illogical. It's impossible. So where that height differential is the highest, it's our argument, respectfully, that it's impossible that plaintiff could have stepped there as he testified, which also raises his credibility. And if I may just touch on one final point with respect to the lighting. The plaintiff alleged that it was poorly lit or not lit at all. It was the evening when he was walking. However, his own photographs from 12 days after the accident tell a different story. There are 2 light fixtures at the very front entrance of this unit, which provide light to the area where he alleged that he fell. Not only that, there were Google Maps images from 1 and 2 years prior that depict the same exact light fixtures. And this is circumstantial evidence that should permit the inference under Lopez v. 1675 Realty, this court 2022, that the area was in fact lit and he was not walking in darkness.
Thank you.
Thank you.
May it please the court, Lori Parkman for plaintiff respondent.
You want to just put the microphone down a little so we can hear you better? Thank you.
Is that better?
Yes, it is.
Okay, thank you. As this court has noted, the photographs in the record show a substantial defect. The measurement is 2 inches. The court did not find that it was closer to 1 inch, but even if it was 1 inch, that constitutes a substantial defect and a tripping hazard under Administrative Code 19142 and Rule 209. And the precedent of this court shows that where the plaintiff shows a substantial defect under the statute, the plaintiff is granted summary judgment on liability. I'd refer you to Tropper, Richard, and Lopez. Specifically, Lopez is interesting because the plaintiff there was properly granted summary judgment on liability upon showing that it was a substantial defect under the statute. In that case, there were issues of fact as to lighting and the plaintiff's distraction, all of these things that defendant tries to raise, but those issues of fact went to the plaintiff's comparative negligence. This court said that plaintiff should not have been granted summary judgment dismissing the affirmative defense of comparative negligence, but the fact that it was a substantial defect under the statute was sufficient to award the plaintiff summary judgment on liability. Here, the plaintiff did not move to dismiss the affirmative defense. We're dealing only with liability. The photographs clearly show that it's over 1/2 inch. Whether it's exactly flush, the ruler shows it's definitely over 1/2 inch. It's definitely over 1 inch. You can see it right there. The argument that defendant makes about the portion of the defect, as Your Honor noted, the plaintiff circled the area where he fell. Defendant is trying to read something into the photographs that is not there. It is not impossible. If you look at the photographs, specifically at 151 and 164 of the record, the tree is multiple feet away from the defect where his right foot fell. There was plenty of room for his left foot there. Similarly, when you speak about the lighting, the defendant is trying to raise things from that the photographs do not show. At 154 of the record, there was lighting illuminating the entryway to the building, which was not near the area. It's multiple, it appears to be around 10 feet away. The photograph was taken at dusk, and you can see the area of illumination is near the entryway, not near the defect. Defendant did not submit any photographs showing the lighting condition at night to show that that illumination from that far away would have been anywhere near the defect.
It's somewhat unusual in the cases I read, trip and fall cases that I read, where we have testimony from the defendant, the super, that said he noticed the raised condition at least 2 years before the accident, and actually says that he called over 50 times to see if the city would come and fix it.
Yes, it is our contention.
So there's certainly notice on the part of the defendants of the issue that's going on here. He seemed to poo-poo that testimony a little bit, but I don't usually find that in the record.
Yes, exactly. Notice was conceded, that's what the plaintiff needed to show, was a substantial defect in notice, and notice was conceded. Plaintiff also argues that these admissions and the testimony of trying so hard to get the city they admitted that it's a dangerous condition. There's simply no reasonable view of this record that it's not a substantial defect and a hazardous condition.
Actually, didn't this person also testify that before the accident, the city actually came and nailed a danger sign, but it got knocked over, and he tried to put some kind of cone, but that got knocked over? I mean, it sounds like there's some acknowledgement that this was a dangerous condition, not just notice, but also that the condition was something that should be protected against or fixed.
Exactly, Your Honor. There was multiple attempts that the city put a sign, and then the defendant themselves, twice, at least in the record, they put up a sign that weather ruined, and then they put up a cone. Plaintiff argues it is an acknowledgement that it was a dangerous condition that they did not fix. They had notice of. Thank you.
Your Honors, I'd like to first...
What does the Administrative Code 19-152A4 and the Rules of the City of New York 2-209 F5-4 say about this defect?
Specifically those codes, Your Honor, I do not have the code in front of me. I apologize.
But don't those code provisions indicate that the defect, even if it is as minimal as you say it is, under those provisions, wouldn't it still be regarded as a defect which you were responsible to repair?
Well, there's no strict liability for a violation of the administrative code. And again, it goes to this court's decision in Trinidad that there's a multitude
Well, there are going to be issues, no one's talking about strict liability. Did you have notice? And
well, and to the notice, I would say a defendant's informal admission is never conclusive evidence of the facts as a matter of law.
But don't those provisions of the administrative code deal with your contentions about the size of the defect? Don't they refute your contentions about it?
Respectfully, Your Honor, I do not believe that they do, especially considering all the issues in the record as to where exactly the plaintiff claims that he fell.
Thank you very much. Oh, I'm sorry.
No, I was just going to say that this was testimony during a deposition. That the super said, yeah.
Defendants? That's correct, and that's considered a classic example still of an informal judicial admission. That finds authority in the matter of Union Indemnity Insurance Company, where they basically, the classic example of an informal judicial admission is a statement made by a party in a deposition, and it's just not conclusive.
Thank you. GCS 2nd Avenue versus Cohen. And again, both the appeals are being argued together.
Sorry? Your Honor?
Both the appeals are being argued together.
Correct. Thank you. Good afternoon. May it please the court. My name is Richard Cohen. I am the defendant appellant pro se. This case involves a 22 action that had 3 defendants, including myself, and a 23 action that is identical to the 22 action, naming only myself. The lower court committed reversible evidence by giving credence to a void nullity of a voluntary discontinuance without prejudice made by the plaintiff. It's a nullity and it was void because it was untimely. The voluntary notice of discontinuance was filed.
Could you put the microphone closer?
The voluntary notice of discontinuance was filed after a responsive pleading. There was no consent of the defendant to the voluntary discontinuance without prejudice. There was no leave sought of the court below, let alone granted.
You're arguing that the first voluntary discontinuance was null and void, and since the second voluntary discontinuance was with prejudice, that was it because that gives res judicata effect, and therefore this action can't proceed anymore.
That is correct, Your Honor. That is what I argue was made in open
Any discussion
court.
whatsoever at the time that the plaintiff's counsel agreed to a voluntary discontinuance with prejudice, was there any discussion in open court about what the effect of that would be, that it was being given with prejudice? What the legal effect of that would be? What I'm bringing up is it doesn't really make any sense because everybody agreed to a voluntary discontinuance with prejudice, but then they were talking about how to re-effect service. And the very nature of a voluntary discontinuance with prejudice is that there's no more action, and that's it.
Correct, Your Honor.
So that seems inherently contradictory on its face, and I'm wondering if anyone discussed it at all during
let
the
me address
hearing.
that, Your Honor, because I was there, and I had made the application to convert it to a discontinuance with prejudice at the time.
And there was no opposition to that, right?
My counsel for the plaintiff at that time said, okay, if I agree to that, will you accept service in the 23 action, the lower court?
Right there, that doesn't make any sense. So is your understanding that plaintiff's counsel was unaware of what the impact of that voluntary discontinuance with prejudice was?
I find that hard to believe, given that my adversary in the lower court has 38 years' worth of experience. On his splash page, his initial website, he specializes in debt collection. So it kind of defies belief that he would not know what the ramifications are of a discontinuance with prejudice.
Neither the plaintiff's counsel or the court brought up this inconsistency between entering into a voluntary discontinuance with prejudice while at the same time talking about subsequent service?
The counsel for the plaintiff asked about this. The judge read it to him because it was agreed in open court, and she read what she wrote down and asked him if he agreed to it, and he said yes.
Do you know where the transcript is for the April 27, 2023 appearance before Judge Adams?
There was no stenographer there that day. However, in the plaintiff respondent's papers, he admits to the facts that I'm stating to you today. He doesn't deny anything that I said occurred before Judge Adams.
He doesn't deny that he agreed to enter into a voluntary discontinuance with prejudice.
No, he does not deny that.
No, I'm just confirming that.
Yes, he does not deny that. A month.
The judge signed off on.
The judge handwrote the order, 2 sentences.
Circumstances here show that this making it with prejudice was really inadvertent. If nothing else, that the judge didn't realize what was happening, probably in the crush of business or whatever, and that really no one ever meant that this should be with prejudice, except for you, of course.
Well, Your Honor, the plaintiff's counsel, a few weeks later, recognizing what he did, moved to vacate that order that memorialized that the discontinuance with prejudice. So he presumably realized, maybe not at the time, but a few weeks later. But this court in Charles v. Levitt states that the stipulation operates as a binding contract, and equity will not relieve a party of obligations under a contract merely subsequently, with the benefit of hindsight, it appears to have been a bad bargain. It wasn't for me to point out what the ramifications of an attorney that specializes debt collection for 38 years. And Justice Adams, I know before she got to the bench, I believe had 14 years of litigation. So I'm sure she was quite aware of the ramifications of entering into a stipulation of discontinuance with prejudice. I thought this case and this matter would be over. I'm not even a primary liability. I was not named in the underlying lawsuit that they were seeking to try and collect from. That just keeps trying to name me as a counsel and a business person to create pressure to try and collect, I guess, on the underlying judgment. against a corporation that's not even a party to this action. And there's still a pending action against 2 other defendants. So I believe the court made reversible error in not referring to the binding stipulation with prejudice that she hand-wrote the 2-sentence memorializing what we agreed to in open court. And it could have been undone, or a motion made to undo it, and it was not addressed or referenced at all in her decisions that we're talking about here today.
Thank you.
Thank you.
Good afternoon, Arnold Joseph for the plaintiff respondent. Let me
Counsel,
yes,
let
Your
me
Honor.
ask you. Wasn't you below, right?
That's for sure.
So there was a voluntary discontinuance with prejudice. There's no question that it was on consent. And it's black letter law that a voluntary discontinuance with prejudice is res judicata. That's it. The action does not go on anymore. Why shouldn't we now enforce that voluntary discontinuance with prejudice?
Well, with all due respect to, not to the court, but to my adversary, number one, they went in and they have the service defense issue, okay? So this is not, they're talking about an agreement. We're not talking about, it's a court order. There's no actual stipulation between the parties. This is a court order.
But you said there's no question that it was consented to.
But the court itself has treated this as if it's not with prejudice ever since it happened.
But counsel, however the court treats it, how do you get around the black letter law without the effect
because
of it?
It makes
Because
no.
we have to interpret it now.
Okay, so let's take the order then if it's an agreement. If it's an agreement, okay, which they represent that it is because it had to be agreed to, right? It's unconscionable. And it's unconscionable in the way that the court below put it in an order.
But unconscionable means that there was some deception going on or some trickery going on. He openly stated in open court, can we convert this into a voluntary discontinuance with prejudice?
What is, okay.
Your side consented to it, the court
What's
ordered it. Where an unconscionability is usually when there's an agreement that's an adhesion contract, not an agreement that's entered into an open
Two things.
court.
What's the consideration and what benefit was there to the plaintiff?
None.
None. And the other thing is there any consideration? None. This is a court, and this is the problem, that it's not really an agreement. It's a court order. And the judge put this language in. And
Well, have you appealed? Is there any appeal from your side
there's
trying
no
to
appeal from
vacate
our
the
side.
order?
What would,
So you haven't moved before us to vacate the order, so we don't have that issue before us.
well, here, Judge, he mentioned, and this is the first thing I'm going to say, he said that the plaintiff never moved to vacate until after, and he realized it. The plaintiff moved to vacate after he moved to dismiss on res judicata.
Did you appeal that?
The denial of the motion, no, that wasn't appealed because the case never changed. The case has been ongoing ever since, as if it never was discontinued. Because, and I'm going to say the second action is still going on. She set it down, the court below set it down for a preliminary conference. There are 2 subsequent orders that are part of the second appeal where the court says, no, this was only voluntarily discontinued. It doesn't say it's voluntarily discontinued with prejudice. So the court
But it
below.
definitely does say that.
But I mean, there is an order. I know it's not one of the orders that's on appeal here, but the order that we've been talking about, the April 27th, 2023
that's
order, is
right.
where the judge puts two sentences.
I think what ends up happening is if, in fact, the case gets dismissed, there's going to be, if this court dismisses the case, because the judge in the court below is treating it just as I say it exists today, that she's not saying it was discontinued with prejudice, because she's
Even though
allowing
she ordered it.
the second, correct, she's allowing the second order to proceed. And then once that would happen, the plaintiff would probably go back and say, hey, listen, look what happened, this case now dismissed, that was never the intent of the court, because clearly it couldn't have been, because why
So then
waive the
someone would
service?
move below and try to vacate it.
Right. That's what's going to end up, yes, I already saw this, Judge.
Okay,
Okay.
thank you.
I just don't understand why you're saying it's an agreement when we agreed to, there was a stipulation of discontinuance with prejudice that the judge memorialized this, that she wanted to put it in writing.
Why do you say it's a stipulation of discontinuance? I'm holding a court order. It's
Right.
not a stipulation, it's a court order. It's not a so-ordered stip.
Because-
Those are different animals.
We were in court, and we said the application was to make a stipulation to convert it to with prejudice. And the judge was in agreement with it, and rather than writing it up and saying, here's a gray sheet, go write it up, she says, I'm going to write it out.
So
for
it's
you."
an order, it's not a stipulation.
it was
I'm not
memorial.
saying they may not have agreed. I'm saying to call it a stipulation is kind of not correct. But it is a court order.
And we did verbally stipulate first, and then she memorialized it in the order. And the verbal stipulation was in front of the judge, and it's not denied in any of the respondents' papers.
But obviously, the next sentence is that you, defendant, accept service of the summons and complaint in the 2023 action.
That was asked of me, and I had no objection to challenge
Of
service, so I
course
said
not, because
yes.
you knew that that wasn't going to hold up. Obviously, nobody else in the room did.
Thank you, that wasn't really a question.
It's rhetorical.
The next case is People versus McLaughlin, and Justice Rodriguez is disqualified.
May it please the court, Clara Hammond-Oakley from the Legal Aid Society on behalf of Mr. McLaughlin. Your Honors, I intend to use my time today to address Mr. McLaughlin's second Huntley point regarding the interrogation with the district attorney. If the court has questions about any of my other points, I welcome them.
Well, let me ask you the first question that comes to mind about that particular issue, which is the harmless error issue. Assuming you're right, and that the question was improper and it gets thrown out, how would that possibly affect the outcome in this case?
So Mr. McLaughlin in this case made two statements. He made one statement to a detective, and then he made one statement to the prosecutor.
Right,
Those
so
were
let's say
not.
we agree with you that statement should get thrown out, the second statement to the DA, but we think you're correct about that. Why would that affect the conviction in this case? Why wouldn't it be harmless error?
Because it changes the strength of the case completely, because Mr. McLaughlin's two statements contradicted each other. In his first statement, he sort of acquiesced to the detective's version of events, which is that he got in a fight with somebody, used an imitation pistol, a BB gun, to hit that person on the head. In the statement with the ADA, he said that he had gotten into a fight with somebody, but affirmatively said that he did not use a gun, did not use an imitation pistol, nothing like that. So those two statements became completely contradictory at that point. If Mr. McLaughlin were to have gone to trial, the prosecutor would have put both those statements into evidence and would have very persuasively argued that Mr. McLaughlin was willing to tell whatever story was going to get him out of trouble, that either way you took it, whichever statement you believed, he lied in one of them.
What about all the other evidence in the case, apart from the statements that supported this, including the DNA match?
Yes, Your Honor. So there was a DNA match in this case. However, that was it. Mr. McLaughlin was not identified by the complainant in this case. And that DNA was also found on a hat that was found 2 hours after police arrived at the scene. Mr. McLaughlin would have...
There's a waiver of appeal here. If we uphold a waiver, do we get to any of these issues?
Your Honor, if you uphold the waiver, I believe you do not get to any of these issues. However, the waiver of appeal in this case is invalid. The court gave Mr. McLaughlin affirmative misinformation about the impact of the waiver. The court said that Mr. McLaughlin would not be able to file a notice of appeal, and that as a result, his sentence would be final. That was also followed by other information that was correct. However, in light of this misinformation, we can't be certain that Mr. McLaughlin adopted the correct interpretation of it. Because that waiver was invalid, Your Honors can reach his substantive points here, and his points are very substantive. I mean, Mr. McLaughlin was told that he had the right to an attorney before he answered any questions, and he responded, I think I should have an attorney with me. I answered enough questions when I went down to the precinct.
There's a written waiver here too, was there not?
Yes, there was a written waiver of appeal. However, when the court says one thing out of its mouth and then presents Mr. McLaughlin with different information in writing, we can't be certain that Mr. McLaughlin adopted the correct interpretation versus the wrong one. And that's especially true in this case where Mr. McLaughlin does have mental health problems, did not graduate from high school. And as the prosecution points out, his criminal history aligns with that misinformation. Mr. McLaughlin had a number of plea cases, none of which resulted in an appeal, and then one trial case where he would not have waived a right to appeal, where he actually got 2 appeals in that case.
You say one of the things is that the court failed to advise defendant of his right to counsel on an appeal. What did it mean when the court said, and in connection with that appeal, if you cannot afford an appeal, one would be assigned to assist you free of charge? You don't think that that conveyed to the defendant that if he needed counsel on appeal, that it would be assigned to him without charge?
I don't think it did because it never used the word attorney or lawyer or counsel or anything like that.
No, it doesn't, but it says in connection with that appeal, if you cannot afford an appeal, one would be assigned to assist you free of charge. You
Yes,
don't think that the defendant understood that that meant he would be given an attorney free of charge?
I think it's possible that Mr. McLaughlin could have made that inferential leap in the moment. I think it's also possible that he didn't,
You think
and
that
that he
that's a
didn't.
leap?
I do think that's a leap.
It's a leap?
The model colloquy says if you cannot afford an attorney, one will be appointed, and that's because the attorney is sort of the important operative noun there, not appeal. There are also costs associated with filing an appeal. You know, Mr. McLaughlin could have understood that to be covering filing fees versus applying to an attorney. But to get back to Mr. McLaughlin's statement, he told the district attorney, I think I should have an attorney with me. I answered enough questions when I went down to the precinct. He followed that up by saying, I meant what I said. And he followed that up by pointing out in a nice, sort of joking way to the district attorney that she was not his lawyer, the lawyer that he had specifically requested be present with him. This was an unequivocal request for counsel. This was very clear. And the Court of Appeals has emphasized the importance of this right. The right to counsel is the right that protects all of your other rights. And that is an important.
I think you certainly have a solid argument as to that second statement. The question is what happens even if you were entitled to have that statement suppressed?
Yes. So if Mr. McLaughlin had that second statement suppressed, it would make his case much stronger. He would have been able to go to trial and persuasively argue just based on the first statement, either that the misidentification based on challenging the DNA in this case, which is very persuasive for juries. Juries do not just see DNA and assume that somebody is guilty. There are lots of arguments Mr. McLaughlin could have made in this case about the DNA. And additionally, he could have argued that his first statement to the detective established a self-defense claim, and that both of those defenses were vitiated by that second statement. Thank you.
May it please the court, Charles Wan for the respondent. Your Honor, the defendant's valid waiver of right to appeal precludes the review of all his suppression claims. Here, the court basically followed the model colloquy. So we believe there was an error in transcription here.
Transcription error.
Yes, Your Honor. That's what we believe, because the court told defendant that if he were to file an appeal, then most of his appellate issues will be precluded, but that there would be limited claims that survive the waiver. And defendant also signed a written waiver, which he admitted to the court that he had reviewed it with his counsel, and there's no reason to doubt that the counsel did not adequately explain the waiver to the defendant. So under all the circumstances, there's no reason to believe that the court actually told the defendant that he cannot file a notice of appeal here. So considering that the waiver is valid and should be upheld, all of defendant's suppression claim would be precluded from review. If there are no questions, people request an affirmance.
Thank you.
I would suggest Your Honors go refer to the model colloquy, because while it is true that there are aspects of what the judge said that come from the model colloquy, the judge was also clearly riffing. The judge did make other mistakes. The judge changed other words, changed order, left out sentences. And so I don't think it's fair to infer that the judge was sitting there reading from the model colloquy and that the court reporter wrote something down wrong. The judge was clearly saying different things. I think that one of the other things that the judge modified from the oral colloquy from the model colloquy that does make this more confusing is that in the model colloquy, the judge is supposed to say that this waiver of appeal will normally make the sentence and conviction final. The judge in this case said that the appeal waiver will make the sentence and conviction final, which dovetailed perfectly with his earlier statement that Mr. McLaughlin would not be able to file a notice of appeal, and directly contradicted his other statements about claims that Mr. McLaughlin might be able to raise. So I think that it would be way too much guesswork to try to say that the court did not say what is written down in the transcription.
Thank you.
Thank you.
Mo versus Zhu.
Should I proceed?
You should.
Good afternoon, Your Honor. My name is Kevin Tang on behalf of the defendant appellant Libo Zhou. And the law, the first issue I'm going to talk about this is 22 CPR 2214, the application of this. It is almost that law is supposed to be settled, 2214, when in this case, defendant appellant submit a opposition and a cross motion 4 days before the motion return day through e-filing at the time because it was during COVID. So it was not going to court, in Central Park. You submit 4 days before the deadline, motion return day. The plaintiff filed a letter rejecting the opposition and the cross motion on the basis that was late because CPR 2214 says that has to be 7 days or 8 days before, 7 days for opposition and 8 days for cross motion. And at that point of time, it was e-filing. So if we go to court, in person, it was almost always the situation. The clerk will say, or the court will say, the plaintiff, right, you need more time to put in reply, we'll give you more time. And that is the situation as I cited in the brief. That's almost, it's a uniform rule. Across the state, that's the rule. That's the law. But the plaintiff, of course, in their opposition, what they say is, you need to give explanation. That is actually not law. That's not, there are several sporadic cases saying that the other side has to give.
Are you saying you put in your request for more time before the time had run on the motion, before the motion was submitted, or was it after the motion was submitted?
No, the motion, the opposition was submitted on time, 4 days. Motion return day is March 15, I believe. And it was submitted on March 11. So there was no lateness. It's just the time to give the plaintiff to reply was kind of shortened by 3 days, right? It's supposed to be 7 days, CPR 2214 says. Now, so 2 years later, we got a letter, a judge issued an order dismissing, striking the opposition and the cross motion for lateness, not timely filed, and then schedule another hearing to determine whether or not any sanctions should be awarded. During the hearing, the plaintiff, asking for sanctions, and the judge asked a question whether or not because that's the motion was plaintiff was moving to strike counterclaims, saying that these counterclaims in the amended answer, right? These counterclaims were duplicative the original counterclaims in the previous case. Now, Your Honor, I was the attorney. I was not the original attorney. I was the second attorney when filed to litigate on that in this case. Number one, if you look at the paperwork, the law is clear. When plaintiff files an amended complaint, the plaintiff opens the door so the defendant can. The amended complaint supersedes the original complaint, so the defendant can file any counterclaims which is available, right? Which is, I mean, even if let's say defendant forget to raise in the first original answer, they can still raise in the amended answer because
Were
the
they
plaintiff-
duplicate? Were the counterclaims duplicative?
No, they're not duplicate. Not only the names, it was 7 counterclaims that were dismissed, and the new counterclaims were not duplicated. For instance, I put in a counterclaim for, there was a breach of contract. On top of this, so I put in a second one for unjust enrichment. That's alternative pleading, because
There was no unjust enrichment counterclaim in the first counterclaims.
no,
right?
it was not there. It was
It
not
wasn't
there.
duplicative.
That was not duplicative. The reason is because there was argument there. There was argument. The retained agreement, plaintiff is arguing saying, look, there is a retained agreement, so you cannot, there is already a contract in existence, so you cannot put in another theory called unjust enrichment. But I know this is not right, because at the pleading stage, this is perfect, because we do not know yet whether or not the original retained agreement is valid. In the instant case, right, our client does not speak English. It was, the retained agreement says it was Chinese translation. The records does not have a Chinese translation. Later through discovery, we found out it was through, in the office, it was plaintiff, the attorney's wife or secretary or office assistant, right, interpret this. So that was a possibility, no meeting of minds. So the defendant, of course, can assert, in the event the retained agreement is vacated, defendant, of course, can say, can go forward with unjust enrichment.
You're going to have more time in rebuttal, okay? Yeah.
Okay.
May I please the court? Good afternoon. My name is Humo. Your Honor, this is a highly
How can you
unusual.
argue that the amended answers counterclaims are the same as the original counterclaims? The amended answer puts in counterclaims for unjust enrichment. There was not a cause of action for that in the first answer. In the amended answer has intentional infliction of emotional distress. That wasn't there. There's a cause of action for breach of attorney-client privilege. That wasn't in the first answer. So clearly there are differences. I mean, maybe the reason for dismissing the original set of answers applies to some or all of the new counterclaims, but they're not the same to say that that's a sanctionable act for having asserted those counterclaims.
The causes of actions were framed in a manner that is essentially relying on the same facts in which
It's different legal theories.
the same theory. With all due respect, Judge Perry wrote 2 decisions. All right, the first decision was the April decision, April 2020, and then there's the other decision, December of 2021, and the Judge Schumacher also visited these issues. In fact, that the counterclaims, the first group of counterclaims that is related to the first complaint, the original complaint, and then they were, by and large, all dismissed except for one claim, that is the breach of contract, which the parties consent to it. Now, there was another cause of action that is the breach of confidentiality that was also dismissed on consent by parties. Now, the remaining 5 causes of actions were dismissed on the ground that they do not support any legal theories in which the relief could be granted. Now, subsequently, the appellant made a motion for summary judgment, and the plaintiff made a motion for to submit an amended complaint, for leave of court to submit an amended complaint, as well as cross motion for sanction, on the ground that the motion for summary judgment, by the way, is improper. That is not supported by facts as well as legal theories. Now, subsequently, they made there was a the decision then was rendered by Judge Perry, that is the December decision, denying a motion for summary judgment on the grounds that these various allegations of defamation, they clearly set forth sufficient factual basis. In fact, Judge Perry ruled that they are per se defamations. in the sense that they allege.
Sorry, I'm a little lost here, because we're talking about the counterclaims, which are not defamation counterclaims. To argue that they're the same, you'd have to compare one counterclaim versus another counterclaim, but you're talking about the main cause of action.
That's correct.
So how does that go to whether or not the counterclaims are duplicative or not?
Subsequently, Judge Schumacher rendered a decision in connection with their counterclaim, the new counterclaim that they raised in their response to the amended complaint. On the
He
ground
awarded
that
sanctions because he said they were duplicative, but how are they duplicative?
they are duplicative in the sense that they rely on the same factual basis.
Right, but that's a different thing. Duplicative means it's a same thing. Like if you dismissed a claim for breach of contract and you brought the same claim for breach of contract, or you dismissed a claim for whatever and you brought the same, but these are different causes of action. The mere fact that they rely on the same set of operative facts, they have to, because that is the facts. That doesn't mean they're duplicative.
However,
I'm not following your argument.
Yeah, even if they rely on the same facts, okay, by rebranding it and recasting it under a different theory, they are legally insufficient. Okay.
But no, but that's not the question. This is a question of whether or not sanctions should have been awarded. We're not talking about whether the claim should have been dismissed or not dismissed. We're talking about whether it was appropriate for the court to sanction the defendants for asserting these counterclaims. You don't normally, even when you dismiss counterclaims, you don't normally sanction attorneys. There has to be something more to justify an award of sanctions. So what's the more?
I think that the court rely on the fact that the counterclaims were interposed improperly on the ground that there's Judge Perry's decision become the law of the case, in the sense
But
that
there wasn't an unjust enrichment claim, and I'm not disagreeing with you that it may not have any validity, but there wasn't an unjust enrichment counterclaim in the first answer, and there is in the second answer. That's clearly different.
the unjust enrichment, although it was not interposed in the initial response, however, subsequently, they interposed their unjust enrichment, which is also relying on the exact same facts, and they may not be, let's say, exact,
Thank you.
duplicative.
Thank you. Thank you very much.
Thank you.
You have 1 minute.
Your Honor, my opposing counsel kept talking based on same facts. But ladies and gentlemen, here, this is the same case, whether or not the original complaint and then goes to the amended complaint. These are all based on what had happened before. It's on the same facts. So what is the essential differences, right? Counsel keep talking it's on the same facts. The defendant's rebranding. When he used the word rebranding, that means it's different. Counterclaims are different. Rebranding using different legal theories. Your Honor, the other thing I have to say is, my opposing counsel said Judge Schumacher ruled on counterclaims. But the knife does not cut both ways, Your Honor. When he struck the opposition, so he didn't even read the contents of the merits of the opposition responses, right? So how could he determine? Now he already stricken it, right? He said, okay, it's late filed, lately, untimely filed. So why all of a sudden he's making a ruling on whether or not the counterclaims has any merits or they're duplicative?
Thank you.
Thank you.
I don't remember how to pronounce it. Genting, New York.
Good afternoon, Your Honor. May it please the court. Andrew St. Laurent for the appellant Pren Mariah, Your Honor. In January 2018, Mr. Mariah was playing video roulette at the defendant Genting's casino. When he was grabbed off the floor by security, he was taken down to a secure room in the basement where he was held for at least 2 hours while casino personnel demanded that he pay money for a broken screen on a gaming machine. Mr. Mariah denied breaking the screen, refused to pay the money, and as a result, and as...
We're familiar with the case, so let's talk about the specific legal arguments.
Yes.
In particular, your argument that it was an illegal rulemaking or inappropriate
Yes, Your Honor.
rulemaking.
So the whole justification here and before the Supreme Court for all of these, what would be torts, except for the fact that there was justification, is this publication of the Gaming Commission called
Let me
Bulletin.
ask you a specific question.
Yes, Your Honor.
Why isn't Bulletin 22, which is what we are talking about, an interpretation of Regulation 9 NYCRR 108 rather than a rule or regulation in itself?
Yes, Your Honor, because, and I'm quoting from Homestead Funding, which is a third department case in our papers, blanket requirements and fixed standards that are to be generally applied in the future are rules subject to state administrative procedure acts, rulemaking.
Right, but, so we have a rule.
Yes.
And the rule says that the agents have the authority to detain individuals as to whom there is probable cause to believe engaged in conduct that violates regulations. So
Yes.
why isn't Bulletin 22 a reasonable interpretation of that rule that I just read, which gives them the authority to detain individuals when there's probable cause to believe they engaged in
Yes, Your Honor,
that
it
violates
gives them the
regulation?
right to detain individuals. It does not mandate 5108.1, which is what you're quoting from, which is a properly promulgated rule, does not say, Genting, you have to have this mini hearing inside the basement of your casino where you, the casino, make a decision whether this damage to a screen was reckless or intentional on one hand or accidental on the other. It doesn't say that you have to...
You say there's a mini hearing, but if the person doesn't pay the restitution, what happens is that the police are called and they go through the regular process. So they're not making the ultimate determination. The choice is always on the part of the person, whether or not they do or do not want to pay the restitution. And if their choice is, I don't want to pay the restitution, I don't think I did anything wrong, then they don't make a determination. They don't have a hearing. They pass them on to the police.
No, Your Honor, that's not what Bulletin 22 calls for. And I don't think that's a fair characterization of the contents of Bulletin 22. Bulletin 22 very specifically says you have procedure 1, if it's determined to be reckless or intentional, which you must follow, which is a mandate, and you have procedure 2, which you must follow, which is a mandate if the damage was accidental. And that's in the record at 313, and the entirety of Bulletin 22 is at 312 to 319.
Right, but if ultimately the person doesn't agree with their analysis of the facts, the person just waits for the police to come.
No, Your Honor, that's not what happens. Respectfully, this is just like the Home Care Association versus Dowling case, which the state had mandated that people who received home health services were entitled to a hearing with notice before discontinuance of their services. And the third department in that case, again, is in the papers, said that the fact that the hearing was required was a mandate that made it a rule that had to be promulgated, and it would have been invalid, and it was invalid in Dowling because it wasn't promulgated. There is a decision path that's here. They're not just grabbing people and say, pay or you have to, we're gonna call the police. What they're saying is, we're gonna grab you, we're gonna put you in the basement. We, the casino, are then gonna go through this fact-finding process. And it's a 3-page fact-finding process, Your Honor, at
Your causes
313.
of action as to the January 19th, 2018 detention were dismissed, most of them on statute of limitation grounds, isn't that so?
But the first and the sixth were not, Your Honor. So those
the
don't
general
provide an
business
alternate
law-
basis.
The general business law survived, right?
Correct, Your Honor. And the negligence claim. And, sorry.
What implicates 349 here?
Your Honor, the fact that the casino, with the pretense of authority that they say was provided by Bulletin 22, took Mr. Mariah and the 1,200 people that are just like him off the casino floor to drag them through this process. This is a rule that imposes a host of mandates on the casino. And why do we know this? Because that's what the Supreme Court held. When the Supreme Court ruled on this, they specifically, in the court's ruling, said that this is a mandate, that there were mandated procedures that the casino had to carry out.
The misleading element for 349 is that they say that they were entitled to rely on Bulletin 22 to take him to the basement?
Yes, Your Honor, but that is not before this court. The Supreme Court held that but for the justification of 22, the 349 counts would survive, and that has not been appealed here by Genting. Who else said that this was a mandate that they had to follow? Genting did. When they argued this case before the Supreme Court, they argued over and over again, this is what we are required to do. This, because we are ordered by the state to carry out these procedures whenever there is a broken screen, that is the defense here. And if this
They're
is...
following the bulletin.
Yes, Your Honor.
The bulletin's following the regulations.
But the bulletin, the regulation is in fact contradictory. The Bulletin 22 contradicts what 5108.1 says.
I'm going to let you explain that in reply.
Okay, thank you, Your Honor. I will start with that.
Good afternoon. May it please the court. Benjamin Greenfield from the law firm of Wilson Elser for the respondent. So as has already been pointed out, my client is a video lottery gaming agent of the state. The video lottery, the New York State Gaming Commission sets forth the regulations.
Really, Bulletin 22 has many more details in it than the original regulation. Why is that not new rulemaking, particularly since 5108 doesn't have any mention of restitution as an option?
Sure.
So why isn't that new rulemaking?
It's absolutely not rulemaking because 5108 forms the underlying basis, right, for the casino to have a security department and to detain people with probable cause for damaging casino.
Right, but isn't being able to retain someone for probable cause different than setting up a whole restitution process, which lets them get out of having the police call?
If anything, it's setting forth a rigorous process for the casino to go through. Without that process in place, then where would the framework be? It would be worse for patrons because all you would have in place would be this 5108, which says the casino has blanket authority with probable cause to detain people to contact police. Instead, what Bulletin 22 sets up is a extremely rigorous framework to analyze all these cases to first determine whether there is probable cause, and then to set forth a very specific procedure to follow in the case of whether it's reckless, or in the case of whether it's intentional, or if it's mistaken. And there are a ton of cases that, as mentioned in the record, where Genting determined that there was no intentional conduct and the person was let go. What Bulletin 22 adds is the option for somebody to pay if they are determined to have damaged the casino machines, which are state assets, in an intentional or reckless manner. It's the option. However, if they decline to do so, then the police are called and the police handle it. So it's not expanding anything. It's not offering a mandatory course that counsel is trying to set forth here. It's offering a framework for 5108 to be applied in a practical matter, which is exactly what the casino did. So viewed in that lens, it is absolutely not rulemaking. It is not violative of due process, as counsel claims, because once again, nobody is being forced to pay. They're given the option, but that is very different than being forced. So viewing it through that lens and the underlying framework that the casino has to carry this out pursuant to state regulation, we look at what the plaintiff proposes to certify here as a class. And let's go through that. The plaintiff is proposing to certify a class of individuals as all those persons that defendant sees on suspicion of damaged casino property, then the defendant demanded pay money and alleged restitution. Nobody was demanded to pay money. For that reason alone, this defined class fails. And moreover, plaintiff proposes 3 essential questions of law that are common to all class members. Whether defendant was authorized to hold plaintiff and class members until paid. They didn't do that. 2, whether defendant engaged in extended detention of plaintiff and class to collect money. They didn't do that here. And in fact, there was a concession in the oral argument that there was no extended holding of the plaintiff in this case. And 3rd, whether defendant is entitled to use self-help to obtain recovery. Again, there was no self-help procedure. There was an option offered. Every one of these cases is going to be an individualized determination, right? If there was underlying probable cause, and if there was conformance with the procedures, the well thought out procedures that are set forth by Bulletin 22. In this case, the court determined that the second detention, there is a question of fact as to whether they should have detained him or not. But he is not commonly situated with the other proposed class members because it's a completely different set of circumstances, right? Where he was determined to have an issue of fact on that second detention. That's not the case of the other class members. It's going to be individualized in each and every single circumstance. Unless there are further questions, thank you very much.
Thank you.
Your Honor, if I may start with the contradiction, which is where I'd left off. What 5108(1) says is that the casino has to detain each individual as to whom there is probable cause to believe that they've engaged in conduct that violates the Act for the purpose of notifying appropriate law enforcement authorities. Every single time. They violate the Act, you notify law enforcement, you hold them for arrest. 22 says exactly the opposite. It says you take them off the floor if they pay. You exclude them from the casino. You take their money, you give them an exclusion order. This is on 314 under sub A4. If they don't pay, if and only if they don't pay, having been so confronted on R13, record 13B, sub 3, then you notify local police and you hold them for police to be arrested. They are directly contradictory. 5108(1) says you arrest everyone as to whom there's probable cause. Bulletin 22 says, no, don't arrest everyone, right? Arrest the ones who you can't get money out of. But if you can get money out of them, don't arrest them.
Thank you.
Thank you very much, Your Honor.
Fortress Credit versus Cohen.
Good afternoon, Your Honors. James M. Catterson from Pillsbury, Winthrop, Shaw, Pittman on behalf of the appellant. Every judge on this panel knows that summary judgment is considered to be a drastic remedy only to be employed when there's no doubt as to the absence of tribal issues. And you also all know that the facts must be viewed in a light most favorable to the non-movement, and every available inference must be drawn in the non-movement's favor. 3213 is merely a subset of summary judgment, and the exact same rules apply. Supreme Court was ultimately faced with a simple question. Did the email exchange of December 14th, combined with the uncontroverted affidavits of both Cohen and Horowitz demonstrating part performance, establish issues of fact which preclude summary judgment? In other words, is there an issue of fact that the loan agreement was modified by the parties so that there is no breach and defendant and
Counsel,
plaintiff
let me
can't?
ask you something. Your whole argument is that this email exchange creates an issue of fact as to whether the loan agreement and guarantee were modified. But I'm looking at the email, and it has very specific language, and it says, please confirm Charles' agreement to the attached below, and will advise K&E and get this in front of senior management. To me, that seems pretty clear language. We'll get this in front of senior management means we'll bring it to senior management, and they're going to decide whether or not they agree with it or not. What is incorrect about that interpretation?
A lot of things, Judge.
Go ahead.
Okay. That's, as you know, on page 943 of the record. The email begins, as before, and as Dean. Dean is the co-chairman of Fortress. It's not the janitor. It's the co-chairman. Albeit broadly and not point by point, a number of requests below aren't acceptable to Fortress. As we've consistently responded, the we is Randall Shai and Dean. Randall Shai is a managing director. Again, he's not the janitor. Attached represents the best and last we will offer. Offer. That's at 2:05 in the afternoon. Horowitz counters at 6:15. That's on page 942 of the record. Horowitz essentially says we have some disagreement and lists a series of points they don't agree with on that offer. What happens next? 11 minutes later, Shy responds the following. Please, it's what you were reading, Judge. Please confirm Charles's agreement to the attached below, and we'll advise K&E and get this in front of senior management. We'll also get K&E reworking the interim amendment. I'll get to that. It's the Fourth Amendment, which is nowhere in their brief except in a parenthetical, in a footnote, so that it can be signed tomorrow or Monday. He's talking about the Fourth Amendment.
Yeah, I'm just trying to hear your specific response to what that language will get this in front of senior management means, other than what it sounds like it means, that we'll put this in front of senior management, and if they agree with it, we'll go forward, and if they don't agree with it, we won't. So what is there in this that contradicts that interpretation, or what are you arguing contradicts that plain meaning interpretation of that language?
It's uncontroverted in the record. In Horowitz's affidavit and Cohen's affidavit, that the parties for the last decade and a half consistently negotiated the agreements through emails, consistently. They reached agreement through email on every single deal for the last decade and a half, and that eventually they would be papered. And not.
Counsel, you say that, but I didn't see any other evidence of prior agreements done that way. I just heard assertions. But even if that's true, that's not a given. That is always a case unless it indicates that, yes, this is an agreement and we will do the paperwork immediately. That would be a much more compelling argument, but that's not what this email says.
Judge, I would agree with you if I was asking you to give me summary judgment. I would. There's not enough to give me summary judgment, but the standard that I started out with is clear that any inferences at all have to go my
Except what we're
client's way.
starting with an agreement, a loan agreement, and the loan agreement clearly says that it must be in writing, signed by the parties to be modified.
I agree.
This email, even if it didn't have the ambiguous language or the language about in front of senior management, clearly doesn't say, it's clearly not a signed writing by the parties. So you're asking to override a clear and unambiguous loan agreement to say that this email would constitute an amendment.
If I may, Judge.
You may.
Page 19 of Fortress's brief, they make the astounding statement, case law could not be more clear. Where an agreement provides that it can be only amended by a signed written agreement, an email cannot amend that agreement, which is essentially the point you just made, Judge. Aiello against Burns. Unanimous from this court, there is one concurrence by Justice Tom, it's Justice Renwick. 2013, she writes the following. The law is abundantly clear in New York that even where a contract specifically contains a non-waiver clause and a provision stating that it cannot be modified except by a writing, it can nevertheless be effectively modified by the actual performance and the party's course of conduct.
I was going to, may I just, I was going to ask that question. So what was the performance that you say takes it out of the usual law? What is the performance specifically that you're referencing?
Two things, Judge. First is the email exchange, but what follows that is the most important part of this, which again is absent from their brief. On November 15th, we were technically in default. They could have declared a default at that time. Instead, the parties drafted a Fourth Amendment.
The Fourth Amendment, was that executed?
No, Judge, it was not executed. What happens after that is they do what all business people do. They continue to talk because nobody wanted to call a $500 million loan in a market like this. Nobody wanted to do that. They continued to talk. They then executed a pre-negotiation agreement on November 30th. They're still talking. Nobody calls a default. They're still talking. It's a $500 million. November 12th, that agreement expires, and what happens? They keep talking. This is the critical part. The email exchange happens after the P&A expires. That Fourth Amendment is still not executed. It's not executed.
You know what? I'm going to let you finish and reply because you're really going way.
Yes, Judge.
Thank you.
May it please the court, Aaron Marks for respondents. I'll start with the Fourth Amendment. The amendment itself, based on the guarantee, was waived, all defenses were waived.
Fourth Amendment never got executed.
The Fourth Amendment was executed.
It was executed.
On
So in
December
that Fourth
21st.
Amendment is an extra $8 million in collateral pledged, right?
Correct.
Why was that done if there wasn't an agreement?
Well, it was an interim agreement. The consideration was extending the payment amortization holiday for Cohen and the borrowers, as well as extending out, the interest payments. The Fourth Amendment is an integrated document with the loan agreement. Fourth Amendment releases, waives, disclaims all claims, with respect to defenses as to the Fourth Amendment and the guarantee. The Fourth Amendment doesn't say anything about the email consideration that they're talking about. So the
Let me ask a question. What about the argument of counsel that the parties uniformly would amend the agreement through an email exchange, and at best, this email exchange creates an ambiguity, preventing summary judgment as to whether or not the parties had agreed to modify the loan agreement?
Yeah, I mean, there's zero record of that. With respect to this loan agreement, which, as Your Honor noted, absolutely requires a signed writing to be amended, there were 4 prior amendments. Every one of them was an integrated document in writing, signed by the parties. The conclusory statement that the parties, had prior agreements or prior amendments by emails is just simply a statement that it has zero support in the record and doesn't create, therefore, a triable issue of fact as to the enforceability of the guarantee.
And why doesn't the language here, please confirm Charles' agreement, and we'll start working on the interim amendment, why doesn't that create an issue of fact as to whether this was an agreement to amend?
So again, first of all,
Other than the fact that the loan agreement requires a writing.
putting that to the side, it does not demonstrate mutual assent. As Your Honor pointed out, Mr. Shai indicated that we were going to take these terms up to senior management, to have them be considered. They entered into the interim amendment so that process could happen. And Mr. Shai also, during the course of this writing, wrote at the top of his email that this is subject to the pre-negotiation agreement. The pre-negotiation agreement also provided that there shall not be an agreement in the absence of a writing. So Mr. Shai, on behalf of Fortress, was also demonstrating his intent that there was not going to be an agreement here until we had a signed writing.
So when does the Fourth Amendment get executed?
The Fourth Amendment gets executed on December 21st, 2023, after the email exchange. And
in January, you declare the default, right?
No, on February 1st, they defaulted. We didn't declare the default until the middle of March.
So but you had earlier indicated that you're not agreeing to the proposal as set forth in the emails, right?
Senior management, correct.
So what does Cohen get for the $8 million in additional collateral that he pledged?
For the $8 million increase of his carry guarantee, he got from November 13th to February 1st, extending out the defaults, extending out his payment obligations that were extensive, that were due on November 13th. They became due February 1st instead. The Fourth Amendment, again, is a integrated document that lays out exactly what the consideration was. This extension in exchange for the increase in the guarantee makes zero reference to the proposal in the email correspondence. If no other questions.
Thank you.
The only evidence of record in this case, other than the documents, are the 2 affidavits. There's a reason.
The only what?
Are the 2 affidavits, one by Cohen and one by Horowitz. Everything you just heard about why Fortress did what it did or why Shai did what Shai did is not in the record. And there's a reason for that, and I think you all know it. Because if Fortress had submitted an affirmation or an affidavit controverting either Cohen or Horowitz, the court would have said, issue of fact. You don't get it on summary judgment. There's an issue of fact. Justice Friedman, there is no businessman on the planet who, faced with a default, would have increased his personal liability by $8 million for nothing. Now they tell you, well, he got a month. That agreement, the Fourth Amendment, which again is nowhere in their papers, the Fourth Amendment was drafted in November. Cohen wouldn't sign it. He wouldn't sign it because he didn't have a deal. He says in his affirmation, and a fair construction, with the inferences going in my client's favor, a fair construction of that email train suggests that Cohen thought he had a deal because there's offer, there's acceptance in that email. Again, I'm not saying we win.
I still go back to my first question. We'll put it before senior management. Doesn't sound like acceptance to me. It sounds like we'll put it before senior management.
But the next
We'll ultimately
email,
have to make the decision.
Judge, they say unequivocally, agreed, accept, agreed, accept, agreed, accept, to every one of those 5
Where's
points.
the unequivocal sentence here? We agree to all these terms, we're done, we have a deal. Where does it say that?
It says,
Where's
please,
that language?
if I could just answer that
You
question.
can answer that question.
The offer is, here's our last and best offer. They write that. We didn't write that. Then when you go to the next email, the perfect example is number 1. There'll be no EOD if we
I'm sorry, I
cannot.
meant in that email itself. My question was directed to that December 14th email. Where is it unequivocal?
It doesn't say, Judge.
Okay, that was my question, whether
Thank
there's
you, Judge.
something there. Thank you. CR versus Episcopal Diocese.
May it please the court, Lori Medley, Epstein, Becker, and Green for defendant, appellant, respondent, the Cathedral School of St. John the Divine. The school is appealing the portion of the order that denies the school's motion to dismiss the complaint. The diocese will separately address its motion for summary judgment. The Supreme Court erred when it found that the complaint sufficiently pleaded the notice requirement necessary to state a cause of action for negligence. Under CPLR 3013 and the case law, plaintiff is required to plead facts and not just general vague allegations of that an employer knew or reasonably should have known that the abuser had a propensity to sexually.
There's only one cause of action here, really, which is premised on negligent hiring. Isn't that so?
Actually, the cause of action asserted is negligence, but it's prepositioned on the idea of negligent hiring, supervision, and retention. Again, under the CPLR, you're still required to plead facts and not just a general conclusory allegation that the employer knew or reasonably should have known of the propensity or the foreseeability that the abuser would sexually abuse the plaintiff. There are no facts asserted here that that any adult with any ability to bind the school as to knowledge, any teachers, any administrators.
What about all the facts alleged here that Bravo notoriously drove the plaintiff to and from the school every day, that plaintiff wore Bravo's jacket throughout the school on a regular basis, that they openly touched each other in sensual and inappropriate ways at the school? I mean, there seems to be a fair amount of specific allegations here that at least allege that the school was on notice of this behavior. And that a parent went to the school.
There are no factual allegations any adult at the school who could bind the school, like a teacher or administrator, actually saw or was aware of this.
But if it's that open and notorious, why wouldn't that at least be enough to go forward in terms of allegations that a reasonable person should have been aware because it was so flagrant in terms of how it was proceeding?
Yeah, as alleged, as with these allegations, again, there's no allegation though. He's saying, the only thing they're saying is open and notorious is driving in a car. Okay, anytime one of us is driving in a car with someone that's—
What about wearing the jacket?
First, it makes you make the leap that—
being openly, touching each other at school.
Again, they're saying flirty in the hallways. When? Was anyone else around? Was it during crowded times when students were actively moving in between classes and moving in between activities, that there was a lot of behavior?
Well, I mean,
What about the other
doesn't
parent?
that usually come with a the next step, whether it's a bill of particulars or something through the discovery. And this is just a complaint. On some of these cases, some of the information comes out a little bit later. In most of the cases that I've read, even if every detail isn't in it, they allow it to go on. This is a 3211 motion, isn't it?
This is a 3211 motion, and again, second and third department and other CBA cases have actually dismissed cases similar to this, where there were just conclusory allegations. Also, too, here, what makes
We've
this
upheld
case...
cases with much less than this.
I'm sorry.
In the first department, we've upheld cases with much more bare bones allegation than these.
But one of the things that makes this case unique, though, too, is that it's even alleged in the complaint, admitted in the complaint, that when the school received secondhand reports of the alleged abuse, the school investigated those complaints or allegations. And the plaintiff, who allegedly was the one who originated these, what turned out to be secondhand allegations, then denied it. She denied the allegation. She denied that there was sexual abuse occurring. There's no other allegation or evidence presented in the complaint that the school had any other information presented to it or was aware of any information after it had investigated to leave it to believe that this sexual abuse was occurring.
I'm going to ask you to change hats for a second. Can you discuss the punitive damages claim and whether or not that should be dismissed?
Yes, under case law, punitive damages is rarely available for cases of ordinary negligence, which is what the cause of action here is asserted. Even in cases of gross negligence, which plaintiff is claiming they're alleging as part of their punitive damages basis, it's still singularly rare, and it has to be in cases where the employer somehow ratified, condoned, ordered that the offending behavior occur.
Let me ask you, because the second department has held that punitive damages claims can go forward in these type of cases, and I don't think the first department has made any kind of definitive ruling yet. How should the first department go? Why shouldn't it follow the second department in allowing them to proceed at this early stage versus going a different way and dismissing them at this very preliminary stage?
Again, it goes to the pleading requirements and that the plaintiff has the burden of sufficiently pleading that there's a basis for punitive damages to begin with. And if they haven't here they've alleged that there was an investigation, that the school looked into the allegations and they found no support for it, mainly because the plaintiff lied and disavowed anything was occurring, that there isn't a claim here for gross negligence to support a claim for punitive damages.
Well, I mean, the first department has addressed this, albeit not recently, which I think your brief relies on that in terms of the punitive damages. Anonymous versus Streitfurt. The second department has, as Justice Kern indicated, seemed to have taken a more liberal approach to this, although they don't explain much about the issue. Although one of the cases in which they've upheld pleading punitive damages, Rubin versus Poly Prep, I mean, that was a case in which the allegations were that multiple teachers employed by Poly Prep had sexually abused the plaintiff over a matter of 5 years. You don't have allegations like that here.
No, we don't. We have allegations of one teacher allegedly sexually abusing her only off of school grounds in his vehicle, in his apartment, when the school was not in custody and control of the plaintiff.
Thank you.
Good afternoon, Your Honors. May it please the Court, Charles Cordova for Defendant Respondent, the Episcopal Diocese of New York. Further to the colloquy that was established about whether plaintiff has a right to continue a claim as to punitive damages against the diocese. Just to follow co-defendant's argument, the complaint is devoid of any malfeasance or misfeasance on behalf of the district. Everything that is itemized is either a school function or an administrative function. More importantly, the lower court, and I fully understand and appreciate Judge Krause's decision, it's silent as to the diocese with respect to punitive damages. The first portion of the decision has a little bit of an explanation as to why the court denied the school's motion to dismiss the plaintiff's punitive damages claim. However, it is silent as to the diocese. I would also point out that the lower court's decision should be reversed because, again, the misapplication of a 3211 motion. The diocese moved under 3212. The diocese had answered The diocese entered or attached an affidavit in support by the diocese archivist of 19 years, Wayne Kempton. Again, the lower court did not take that affidavit into consideration when rendering its decision. So again, I believe that it should be reversed or at the very least remanded back to the lower court for determination not only as to punitive damages, but with respect to the underlying acts. The diocese did not hire, did not fire, did not supervise the perpetrator here, Bravo. There's no nexus. Well, plaintiff says that the school and the diocese, but only points to acts done by the school, not the diocese. So there is obviously an agency relationship when it comes to ecclesiastical and religious faith-based study. There's back and forth with respect to that, but the diocese, again, different than the Catholic Church, because I've represented both. The Episcopal Diocese, it's not a pyramid where you have the Holy Father on down insofar as responsibility. It's a different mechanism. It's a different structure. In opposition, plaintiff brought an affidavit by an expert, a defrocked priest of the Catholic Church, who, and again, just added all of the canon law, the Episcopal canon law, as well as the directories, and in there trying to create this employer-employee relationship. The diocese does not believe that the record reflects any such, and the case should be dismissed as to the diocese. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Kyle Sheedo from Herman Law on behalf of the plaintiff respondent.
So what do you allege in the complaint here which makes this a case of punitive damages?
The fact that the school had an investigation shows that they had actual notice, that they believed the allegations, whether they were founded or not, and then allowed the teacher.
They asked the plaintiff and she denied it, and they didn't continue with the investigation or do anything about that. So that certainly falls potentially as being negligent or negligent hiring cause of action. But what is it about that which shows that it rises to the level of punitive damages?
Just first, respectfully, I would say it goes to retention and supervision.
You know, some of the things that's pointed to is whether it's condoned, whether they actually know about it, they know about an act, or there's a cover-up.
Consents to, ratifies.
What is it that you allege that shows a cover-up or a condoning of this conduct?
They allowed the teacher to continue in his role at the school, and the abuse continued. So either their investigation was inadequate or it uncovered information which made.
How isn't that negligent?
She denied it.
She's a 13.
It's specifically in the context of a punitive damages claim, we have to show something more. In this case, she denied it happened. They did an investigation. So how could they have been the type of malicious conduct that required for punitive damages where she specifically denied it was happening?
She was a 13-year-old girl at the time. An investigation that is trauma-informed would understand that a victim
Let's say they got it wrong. They got it wrong. They should have realized that a 13-year-old girl in that situation isn't necessarily going to be truthful. So they got it wrong. But that is a very different kind of allegation than the kind of behavior that would justify punitive damages. So what here differentiates it from they got it wrong, they should have realized, versus punitive damages?
By knowingly retaining the unfit servant, that means separate.
But that's every case. That's every case brought under this statute is involving that. There is no case if you don't have that.
Correct.
What you're telling us, I believe, is that every CVA case is a case for punitive damages.
Not everyone, because municipalities, punitive damages aren't available. But in the instance where the school covers up, and this is a private school, not a municipal school, where the
That's
school...
very interesting what you just said, where the school covers up. But there's no indication that, there's no allegation here that the school covered up. There's an allegation that the school asked the student, and she's denied it, and they didn't do something further. Bad decision, but it hardly can be said to be an allegation of a cover-up. You don't point to anything that anyone did that constituted a cover-up or a condoning of it. Witness the fact that they did investigate it.
At the pleading stage, I believe we have sufficiently met what is required as far as punitive damages, which are an add-on type of damages to the complaint, and therefore,
So that comes back to that. In fact, you're telling us that every CVA case is a punitive damage case,
I think it's fact-dependent.
other than if it's against a municipality.
So, but the, I
A
mean, I have to-
constructive notice case may not be a punitive
So
damages
if
case.
you look at Rubin, which is, you point to the second department cases, Rubin versus Poly Prep, so there you had many teachers involved in it. You don't even have something like that here. You've got one teacher who they do an investigation about, they get a denial of it, and that's all you point to.
Correct. We may not have the culture that existed at the Poly Prep case for the Rubin situation, but by affirming, ratifying, consenting to, or otherwise deliberately retaining the unfit teacher, they have opened up the door to potential punitive damages.
That's all their negligence. There's nothing different about that than just, was that a reasonable decision for them to have made? There's nothing in that that speaks of outrageousness.
And that can be addressed appropriately after discovery is completed at the summary
It's
judgment.
your complaint. I mean, you've got to make some allegation which makes out the claim. I know, and I recognize that we've held, and the second department has held, the requirements are liberal, but we haven't had that there are no requirements for pleading punitive damages.
Respectfully, I think viewing the complaint in the light most favorable to the plaintiff, drawing every reasonable inference, there are inferences that can be drawn which substantiate that the school was willful, wanton, or reckless as it relates to the personal well-being of the plaintiff, and therefore punitive damages can survive the pleading stage with what we have right now, and more discovery is needed on that issue.
You do also plead that after the so-called investigation where they questioned a 13-year-old girl, they said deny and they do nothing else, that the abuse did continue. You also allege that the defendants concealed their knowledge of what was happening here. Why isn't that enough?
I believe that is enough. Yes, that is correct. That
at this stage,
at the pleading stage, viewing the complaint as a whole, I believe it is enough for the punitive damages to continue.
Did the defendant conceal their knowledge of the abuse going on?
They did not notify the student of any dangerous propensities of the teacher. They didn't notify.
Did they notify the police?
Excuse me?
Did they call the police?
No, they did not.
Who did they interview? The student?
They interviewed the student, her friend.
They interviewed a 13-year-old victim.
Correct.
And that's their investigation.
That's what we alleged in the complaint because that's what we knew.
So every time there's any allegation of this nature which arises in a school, the school has an obligation to call the police about this, to call the police in, even if they don't have facts which substantiate the complaint.
That would be dependent on Article 23B from the education law, which does clarify that unlike the
Well,
social
you just
service-
indicated that the fact that they didn't call the police supports a claim for punitive damages. That means that you're saying that they should have called the police here.
Viewing the complaint in the light most favorable to us, yes.
Did they do anything else other than interview the 13-year-old victim?
I believe they interviewed the parents and the friend that she had confided in.
Thank you.
And it,
Thank you.
Just to go back quickly to the punitive damages claim, now the complaint alleges is that they interviewed the plaintiff, they interviewed the parents, they interviewed the other parents who allegedly reported the complaints of abuse, they interviewed the friends who were involved and the abuser himself. And it does not allege that there was any information or obtained from these interviews that would lead the school to find that the secondhand reports that she was being sexually abused by Bravo were accurate or true. The only thing that
Did the school do anything to monitor afterwards? Because the complaint does allege that the abuse continued after this interview.
What they allege, and they allege in their opposition brief too, is that the abuse continued off campus. They don't allege that there was anything that could be done to monitor that, whether she was going off campus after school to his apartment, whether she was going off campus and meeting him somewhere and getting in his car.
You mean to say that after that interview, the school continued to monitor and noticed that this student was riding back and forth to school in his car every day, or that there's this touching in the hallway, or that there's this inappropriate flirting, that the school just throws up their hands and that's it? Nothing here?
The complaint doesn't allege that the school threw up its hands. The complaint doesn't allege that there was anyone at the school who had actual or constructive knowledge that any of this was going on, that they had any knowledge that she was riding in a car with.
Isn't it a fair inference that if he's driving her to and from school and that these flirtatious actions are going on, inappropriate conduct in the school, that someone in the school noticed it? That's not a fair inference, from at least at this stage?
Again, they're required to meet their pleading requirement, and that is not what's pled in the complaint.
Thank you.
I would just, in conclusion, I'd just like to point out that the perpetrator here is not an ordained priest of the diocese. He's non-secular. He was hired by the school. Diocese did not have any input whatsoever in regard to approving the appointment or the employment or the termination.
So are you saying you think you should be completely out of the case for that reason, both on the negligence claims and the punitive damages claims?
I've yet to hear in open court here of any allegations as to what the diocese did or did not do. Yes, John, that's what I'm saying.
Could the relationship between the diocese and the school be compared to the relationship of a principal in the school?
No, I don't believe so.
Why not?
Because the principal of the school has the autonomy to direct teachers, enforce their or report and supervise their activities. The diocese does not do that.
So what is the relationship that the diocese has, or authority over the school?
I don't think authority is the proper word.
Okay.
That's the point. The diocese is a jurisdiction. When churches and schools closes, it serves as a reliquary for all of their documents. Okay. Also, there is a file for each church, for each school affiliated with that church. And there is obviously back and forth with respect to questions of theological thought and ecclesiastical and the canons of law within the church, within the diocese, for the appointment of ordained priests, not for non-secular folks.
Not for teachers.
Correct.
Thank you.
Thank you, John.
Triad Capital versus Patino.
Your Honors, Counsel, good afternoon. May it please the Court. My name is Evan Van Leer Greenberg, and I am here today for the appellant, Triad Capital, LLC. So, we're a nation of laws, even though maybe after January 20th it doesn't always seem that way. In this case, it boils down to one rule. The rule is 2-02D13 of the Rules of the City of New York, which control whether or not a successor property owner should be held to the confines of a harassment order.
Let me ask you a specific
Yes, Your Honor.
So your primary argument is that because the harassment order wasn't registered and the rules require it to be registered, it's ineffective as against the successive owner, and in a contrary interpretation by the law board is irrational. So I guess my question for you is, it does say that the harassment order should be registered, but it is completely silent, the rules, as to what happens if it's not registered. It doesn't say that if it's not registered, successive owners won't be bound, they will be bound. It's silent, so there's no rule that's directly on point as to that issue. Why isn't the loft board's determination, which arguably is entitled to deference in this situation, because it's not a clear question of reading a rule and understanding its import, why isn't their interpretation entitled to some deference and not irrational? Because reasonable people could disagree about what the import of this rule is, since it doesn't say what the effect is. I know that's a long question, but.
It's a very long question. It has about 3 parts, and I'm going to try to unpack it for you. So the first question is about statutory interpretation and deference. And the Court of Appeals has held specifically, and I talk about this case at length in my reply brief, it's called the claim of Gruber. And in the claim of Gruber, there is a methodology as to when an administrative agency is entitled to deference. And an administrative agency is not entitled to deference, and the judiciary is entitled to view the statute and make its rulings when.
Aren't they interpreting their own rules and laws that apply to the work that that DHCR and Health Board does? No?
You're absolutely right. And when that occurs, the statutory deference language from Gruber, from the Court of Appeals, 1996, says, in such circumstances, the judiciary need not accord any deference to the agency's determination and is free to ascertain.
Let's put deference aside for a minute.
Sure.
Because we could spend the whole time you're arguing on deference. But even if there's no deference, why couldn't reasonable people have different views about what the impact of a lack of registration statement is? And since this is an Article 78 proceeding, where there's basically an irrationality standard, why shouldn't we uphold their determination, which arguably is not unreasonable? It's just people could have different interpretations.
So it is rather unreasonable. The words in the statute are specifically, notice of such order shall be filed by the Law Board in the office of the city register.
That's true, Counsel, but what it doesn't say is that the filing with the register is an express condition of the order for it to be imposed on successor liability.
So statutory intent, right? So in 1990, this court held specifically in the matter of Lower Manhattan versus loft tenants versus the Loft Board that the same statute did not apply to successor property owners at all. There was no successor liability to a successor property owner of a harassment order. Only.
But now it specifically says that it does apply.
And there are conditions to it. So the first sentence says, I'm sorry to interrupt you, Justice.
Finish your answer.
It doesn't say that registration is a condition precedent to imposing liability on a successor owner. Nowhere does it say that.
It says, the order shall be binding upon all persons and parties who succeed to the landlord's interest in the premises. And then it sets forth in two sentences, the exact requirements to do so. A copy of the board's order containing the finding of harassment shall be mailed to the complainant, the owner, and all occupants of the building, and any other parties to the proceeding. Then the next sentence, notice of such order shall be filed by the Loft Board in the office of the city register.
When did your clients become aware of the harassment order?
After the purchase. There was no physical way.
After the purchase of what? Of the building? After the purchase of the apartments?
After the building.
Okay, but you knew about it before the purchase of the apartments, correct?
It appears so from the buyout
I think it's pretty
agreement.
strong that you did.
I can't step away from that.
Okay, well, all right, so let's assume that you did. You had a mechanism to terminate it, right? You could have moved to terminate the harassment.
So what your argument is supposing is the fact that the order itself applies to my client.
Let's assume that it does. If it applies, right? Because you're saying that it doesn't because it wasn't filed with the register. Let's put that to the side. Let's not decide that for this instant. Let's say that it does apply. Your client had a mechanism, right? Which is move to terminate the harassment finding. Could have done that, but did not.
So in these particular
Is that a yes or no?
The answer, and I hear your question. In these particular circumstances, though, and what's functionally missing here, is that my clients are faced with one thing. They have these two tenants that are willing to be bought out, which is a rare thing in the Loft Board and under the Loft law. So my clients acted. And as the record makes incredibly clear, my clients, as the successor property owner, even though out of proper timing, if you will, corrected every issue.
We're familiar with the record, and you have time on that.
Okay.
But we're familiar with the record. Thank you. Thank you.
Okay. Yes, Your Honor.
Good afternoon, Your Honors. May it please the court, Diana Lawless, on behalf of the Loft Board.
So you shall file with the city.
It says you shall. I mean, yeah.
They didn't do it, so why shouldn't it be held against them?
Because as the Loft, so we're talking about, as Justice Kern said, we talk about the rationality of this decision, right? So we have our textual argument or arguments that they're not connected.
So what is that provision there for? You know, does it mean if you want to abide by it, you abide by it? If you don't want to, you don't have to. It's just your discretion what you want to do. What's it there for?
Well, I mean, I think it's there as a mechanism for notice, but I think it's the reason that in this case, what's important is that it's not the sole mechanism of notice, and I think it was rational for
Well, when you talk about notice in the real estate context, so someone looks at the record to this building, and there's an affidavit from a title searcher on this. Someone looks at the title for this building, looks for this loft board. It doesn't have this on file. They say, well, obviously the loft board really doesn't care about this or whatever. I'm buying it. Why should I be subject to it? The regulation says you're supposed to file it. You didn't file it. I bought it without being filed. Why should I be bound by it?
Well, two things, Your Honor. First of all the cases that we cited is that you are bound not by a title search, but by proceedings.
Actual knowledge.
Well, first of all, constructive
no
and
question
actual.
they had actual,
Right,
they
they have
had
actual
actual knowledge before they buy the apartments.
Right.
But they don't have actual knowledge, apparently, before, or do you contend otherwise, before they buy the building?
I don't know that it matters that they had actual knowledge before they bought the building, because all that matters here is
your
what
position, it definitely doesn't matter. I understand
Yeah.
that, but why isn't what is the flaw in that argument for them to say, look, I looked at the title to this building, and according to the requirements for the loft board, they were supposed to file it. They didn't file it. They don't have a right to enforce this pre-existing order against me.
Because they should have constructive notice, and the law charged them with constructive notice of the loft board's records. Had they looked at the loft board's records for the building, they would have found out that this happened.
That's assuming that there's an obligation for someone searching title to go check it.
Well, that's
But
why
their title searcher says no one would do that.
Well, Your Honor, well, first of all, it's the title search, right, that came up for the first time in the Article 78 proceeding. You can't consider that affidavit. But we cited cases that say that it's enough for there to be prospective notice on the contents of building-by-building records. This is in the building-by-building records maintained by the loft board.
So wouldn't it be part of due diligence that if a person is buying a building that's subject to the loft board jurisdiction, that they would look to see if there have been any harassment findings?
Yes, but that's what we said. That's why we cited the I would say ancient principle that you
Why
have.
would due diligence require that when your own rule says that you're supposed to file it and you didn't?
Right. I mean,
what is that sentence there for? What you're telling us is that it doesn't matter whether that sentence is there or not.
But
You don't
I
have
think
to abide by it.
I think, Your Honor, I think it's different, right? If we're talking about the rationality standard of the specific determination of the loft board, and I think that if we were having a discussion about whether or not this rule is legal and what the rule says, it'd be a different story. It's not a challenge to the regulation. It's a challenge to, is it rational to hold them to the regulation? The answer is yes, because they
It's
should
a
have.
challenge, but it's also what's the effect of your not living up to your own regulation.
Right, which is that they had other means of notice. If you look at the sentence before that, right, that they cite too, they say that it also gets mailed to you. So it would get mailed to the prior owner. They're separate sentences. You're bound. It gets mailed
It's
to the
not
prior.
mailed to them.
Right, it wasn't mailed to them. But they had actual knowledge. So it was rational to hold them to this because they had, so the rule.
But they say they didn't have actual knowledge before they actually bought the building. I mean, once they've got the building, then other things are happening. But shouldn't they have had knowledge before they bought the building?
Well, I mean, I think, I mean.
Yes.
They have constructive knowledge. They had constructive knowledge.
Before?
From the loft board's records,
How do you get the loft board records? Is it online? Is it easy to obtain these loft board
Well, this
records?
is from
Is it
2000.
just online?
Well, Your Honor, this is from 2007. I know from at least the last decade and a half, these orders are very easily searchable online. I don't know what the status of the loft board records were in 2007 when this purchase occurred. But
Is it fair to say that if they had made an inquiry of the loft board in 2007, they would have known or they would have been informed of the harassment order?
Yes. Because they would have looked at the orders, they would have looked at the regulations of the loft board. I mean, I think, setting aside that it's a little hard to believe they wouldn't know that this building would have been subject to the loft board because of its lack of a residential certificate of occupancy with residential tenants. But they knew about this order when they went to buy the rights, right? And they had.
I don't know what the justification is for the loft board enforcing this harassment order against the petitioner when you disregarded your own regulation.
I think here that all we can say is that we know that it was never recorded because it's not in ACRIS. So we know that it was not recorded. But we know here that this rule was designed to apply to subsequent purchasers. So I can't explain what happened in 2007, or 2006, but we know that this owner should have had constructive notice from the loft board records and did have actual notice, at least at the time they entered into the sale of rights. And I know one of your honors said, oh, they can move to vacate it. They couldn't have done that till 2009. That was on the face of the order. So they probably should have waited for the sale. And if you look at the term of the sale, it says that we agree that this should be vacated. It's something they couldn't have actually done under the law under that time. So they should have reconsidered what they were doing at the time when they went to have the sale of rights. They definitely knew about it at the time. Because the harassment order was still in effect, it wasn't vacated. They couldn't have sold it, and it was rational for the loft board to determine that because of the constructive notice in the loft board records and because of their actual notice of this, that they can't benefit from the prior owner selling the building to them and them trying to get out from under a harassment finding from the prior owner.
Thank you.
Thank you, Your Honors.
2 short points. I'll try to make it very quick. The first is the order of Judge Ngorin. My counsel, respondent's counsel, admits that it's completely flawed. He cites an administrative rule provision that does not apply, and the only other case that he relies upon to nullify this loft board rule is called 7 Vestry, and, quote, respondent's counsel, it's factually different. That's one. So if this court's going to take a look at this, I'd ask you to take a complete de novo review of all of the facts, because I found that the underlying order from the Supreme Court was flawed. Secondly, and I just want to address one more point. There's a case called Rosenbaum versus the City of New York, which is cited in the respondent's brief at page 25. And the facts are substantially similar to this case. There's an HPD tax lien, and the successor owner, of the property had constructive notice that it existed, but there was a mandatory statutory recording requirement for the tax lien. Specifically, in the case before us, the city conceitedly failed to file any purchase or work orders, but claims nonetheless the plaintiff had actual knowledge of 7A loans and therefore was not a purchaser in good faith.
We'll look at the case, counsel.
That case specifically, in conclusion, stands for the proposition that because HPD failed to follow the mandatory recording statute, the successor owner was not on the hook for the HPD loans.
Thank you.
Thank you very much.
People versus Valera.
Good afternoon, Rachel Lindy from the Office of the Appellate Defender on behalf of Pedro Valera. Pedro Valera's 20-year prison sentence for his first felony convictions is excessive and should be reduced. When he was still a young adult, Mr. Valera engaged in conduct with serious consequences. Without excusing his actions, his behavior must nevertheless be understood in context. He had been exposed to violence from a young age, enduring formative trauma that had been left untreated. When he was just a small child, at the age of 6, he witnessed his young cousin be shot to death by a gun, and he grew up in an abusive household in which he watched his father abuse his mother before his father abandoned his family. His difficulties extended into his schooling, where even though he had an IEP, he struggled in his special education classes, and ultimately he dropped out of high school. At that time, in order to support himself, he began selling marijuana in his neighborhood. At that point, that exposed him to further violence.
The law court know all this?
It did, Your Honor, and this court has a broad interest of justice jurisdiction to still reduce his sentence. Regardless, without deference to the court below, that was again recently reaffirmed by the Court of Appeals in People versus Brisbane. And so these mitigating circumstances should so be considered here. He had never, I apologize, he struggled with his mental health, but was never diagnosed or received medication until his incarceration on the
So what do you say about the waiver of right to appeal here?
Apologies?
The waiver of right to appeal.
The waiver here was invalid for several reasons. Critically, the oral colloquy was insufficient. The court did not explain that the right to appeal was separate and distinct from the rights ordinarily given up upon a guilty plea. And further conflated those rights by saying that had his case gone to trial, he would have had a right to appeal, which further confused the issue.
It's confusing here, right? Because, wait, is the right case? Because there was a trial and then there was a guilty plea.
That's right. Yes, and so he had gone to trial. There was a mistrial, and then he pleaded guilty afterwards. And the court again did conflate those rights by saying, do you understand that had your case gone to trial, had you been convicted, then you could contest on appeal any errors or violations of your rights. It did not ever explain that those would be that appeal right would also apply to a guilty plea. And so his waiver of appeal is invalid. In addition, his circumstances further indicate the invalidity of his waiver. He, as I said, never finished high school. He had learning disabilities, and this was his first felony conviction. So he did not have that prior experience. Those circumstances are critical to understanding why his waiver is invalid. And further, returning to the mitigation that this court should therefore consider in reducing his sentence, Mr. Valera demonstrated maturity and growth from the time of his arrest until his sentencing over 3 years later. After initially struggling in the first few months of his incarceration, once he had received treatment for the very first time of his life, received psychiatric care, and as he grew and matured, he began engaging in programming addressing the root causes of violent behavior, including stress and anger management programming. He also participated in vocational programming, beginning to invest in his future. All of this should be considered in finding his 20-year sentence, which is 15 years above the minimum available to him and 5 years greater than the minimum term he could have served had he in fact been convicted of murder, which he was not. His current sentence is excessive.
Thank you.
Thank you.
Good afternoon, Your Honors. Michael Tarburton for the people. Your Honors, the defendant's waiver of appeal was fully knowing and voluntary. In particular, he signed this very detailed written waiver of appeal, and he assured the plea court that he had gone over this, had reviewed the written waiver with his attorney before he signed that. That written waiver was sufficient to clarify any ambiguities in the court's oral colloquy. In addition, Your Honor...
Could you move the mic up a little bit, just...
Sure. Is this better?
Thank you.
Okay, sure. In addition, Your Honors, the defendant actually had a very lenient, a very favorable disposition in this case. It makes sense that he would have bargained away his right to appeal in exchange for that. This is a rational deal. It made sense that he would exchange his right to appeal for it. After all, this plea deal allowed him to avoid the possibility, a very strong possibility, of a life sentence and consecutive sentencing in his prison contraband case. So again,
He avoided a retrial on murder too.
Yes, Your Honor. And it's significant, Your Honor, that in the first trial, he was so concerned about the evidence, in this case his attorneys were, that he actually conceded his guilt of manslaughter in an effort to persuade the jury not to convict him of murder, and it didn't work. So if he proceeded to trial again, he was facing the near certainty of a conviction for manslaughter. He could have gotten up to 25 years just for that, and a very real risk of a conviction for murder and a life sentence for that, and of course exposure to a consecutive sentence for the prison contraband case. So this was a favorable plea deal. It made sense that he would waive his right to appeal to get that. In addition, he hadn't a felony conviction before, but he pled guilty several times before, and he'd just gone through a trial in this case. So he's very familiar with the criminal justice system at this point. He's 28 years old. He's not a kid. So he knew what he was doing when he waived his right to appeal. In addition, on the merits, again, this is a very favorable disposition, and it was one that was appropriate in the circumstances. After all, the defendant, while acknowledging that he has this childhood trauma and that's a legitimate mitigator, even so, there's only so far you can mitigate a case like this. He shot down a man he grew up with over a drug debt, and this is a very deliberate crime. A week before, he had publicly threatened to get a gun and kill him. The day before the crime, he told a friend of his that the next time I see him, I'm going to kill him. And sure enough, the next time he saw him...
He killed someone with whom he had a long-standing relationship.
Yes, Your Honor.
And if I'm recalling correctly, someone urged the defendant to stay away, not do something which will leave him being very sorry, and he disregarded that advice and warning.
Right, he did. His friend Peralta, who testified.
Peralta, right, that was...
Right, he told him, he heard the defendant's other friends, they're sitting on a stoop, their other friends are saying, are you going to let this guy, little Little Rabbit, you got to let him get away with that, you should put a bullet in his head. Peralta testified.
Peralta told him to
Right.
stay away and
He caught him later on. He said, "Don't let them gas you up to do something stupid." And in response, he said, "The next time I see him, I'm going to kill him." And that's what he did. He shot him down. He grew up with this man. So that and after that, he showed no remorse for this. Instead of showing any kind of remorse, he was a fugitive for 6 months. He tried to tamper with parole to keep him from testifying. Then in prison, he was caught with a 2-inch scalpel blade. He was involved in another prison assault for which he was sentenced to 5 years ultimately. So his potential rehabilitation here was fairly dim. So the sentence in this case was appropriate in these circumstances.
Thank you.
Thank you, Your Honors.
Just a few quick points. Apologies. Returning to in regards to respondent's point about the bargain and the prior trial, the jury below was in the best position to judge the credibility of the witnesses that testified and whether or not it believed his conduct to have been intentional, and the jury did not convict him of intentional murder. This was a hung jury with not just one person believing so, but several jurors refusing to so convict him. And this was after Mr. Valera did not have the strongest possible representation at trial. His lawyer, his primary lawyer, Daniel Scott, fell asleep at multiple points at trial, and the second chair had to step in at the last minute and essentially take over that trial for him. And so that context is important to understand the plea he ultimately took, in addition to the overarching mitigating circumstances that should be considered. Briefly to the waiver point.
Thank you. Your time's
Okay,
up.
thank you.
Thank you very much.